Welcome to the Only Male Cruise Show, the podcast. I am the only male cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right. It ain't my fault, y'all. StreamYard was clowning on me, okay? And it was making the intro stop and stutter and stop. So I said, let me come back up in through here, okay? Anyway, thanks for pulling up. The Only Male Cruise Show, the podcast. I am the Only Male Cruise. I want to thank everybody for pulling up today's episode. The government's response, okay? And I did cover this, I think it was about a week or two ago. Bonjean had submitted a motion on behalf of Kelz. We covered that. June Brown submitted a motion, and the government responded to that. And they responded to that, a couple of days ago, actually. So the only thing we're waiting on now is what the judge is going to say, and we're also going to see if Bonjean has a response to the government's motion. So we're waiting. But today we are going to go over what the government said, and then also how June Brown and them came really right back the same day, damn near, to respond to what the government's talking about. Let me shout out the chat, because y'all, I appreciate y'all pulling up. Be sure to hit the like button, share, subscribe if you haven't already. Replay gang, you know what time it is. Leave a comment, because you know I want to hear from you. All right, shout out to Tiffany Only Please, aka Twitter Alert. I made it. Okay, good. I'm glad you did come. Nisha, thanks for pulling up. Appreciate y'all. K-Baby in the house. We got the number one Ma Shay Baby up in here. Miss Lackey, girl, you're looking good on IG. Thanks for pulling up. Appreciate you so much. All right, y'all. I don't want to waste y'all time. Y'all know how I like to do it. Get in and get right on out. All right. But I got an attitude. I'm so upset. I got an attitude. I got an attitude with our boy over there on Twitter, Mr. Jason Meisner. And, you know, he keeps posting these pictures of Kelz in that orange jumpsuit. But then you post all these other Chicago, quote unquote, criminals, indictees, etc. Where's their mugshot? Where's their orange jumpsuit at? So I'm giving him the business. I presume that I will be blocked shortly, because I don't care what he's posting. I'm asking him, where's the orange jumpsuit at? You want to put it on Kelz like that? But anyway. All right. And then one other thing that I wanted to bring y'all's attention. The judge, Mr. Harry Linenweber. Okay, so he actually presided over, or he weighed in on Larry Hoover's request to be, to have a sentence done and over with and let him be free. And of course, everyone knows, he didn't give it up. He said, no, you come back another time, but right now I'm not going to let you go. But I did find a person that had submitted for this was a few years ago, had asked for, his sentence to be completed or commuted or whatever. And the Judge Harry, he said, well, you know what? I'm going to let you go. Because if you haven't learned, if prison hasn't taught you anything by now and you haven't learned, you're never going to learn. So I'm going to set you free. But he wasn't inclined to let Larry Hoover free. And Hoover been in there since forever. So that is either That's his current mindset, okay, on Larry Hoover. Now, will that seep over into, how he rules on Kelz? Will that seep over into how he, you know, interprets these motions on behalf of Kelz? That's something to keep in mind when we look at, um, upcoming motions and then just the trial in total. All right. So with that being said, let's get into it. So here's what the government's talking about. And the government is being a little spicy. Okay. They're being just a little too spicy for me because they essentially, basically what they said was, um, if we dare you to testify. And now I'm paraphrasing. Okay. But when I read it to you, you'll see what I'm talking about. Basically, we dare you to testify. If you open up this door to questioning, we coming through it. Okay, government. All right. We hear you. So it just kind of got me irritated. I don't know. Between that and Jason Meisner on Twitter. Ooh. All right, let's get into this motion. Okay, so with the government, he says here, they're saying here, okay, we're responding to defendant Milton Brown and Robert Kelly's consolidated motions in limine. So they're doing this all in one, it's a one-hit wonder. They're addressing both of them this way. It says the defendant's motion to preclude evidence of booking hotel rooms and making travel arrangements for minor 4 and 6 should be denied. Defendants Brown and Kelly move to exclude what they contend is certain other crimes, wrong acts evidence as impermissible propensity evidence under this Rule 404. It says this motion is without merit because the acts constitute direct evidence of the charged offenses. Now, Rule 404 applies to evidence of other crimes, wrongs, or acts. And so what the government is saying here is that if we submit this evidence as not wrong crimes or whatever, but as direct evidence of what they're guilty of, then Rule 404 doesn't apply. And so you should not allow us to, or prevent us from presenting this evidence. That's essentially what they're saying here. And they go further to say, Rule 404 is inapplicable where the bad acts alleged are really direct evidence of an essential part of the crime charged. Time and time again, we have said that Rule 404 does not apply to direct evidence of the charged crime. Okay. Even more, we have noted specifically evidence directly pertaining to a defendant's role in a charged conspiracy is not excluded by Rule 404. So, are they going to is Lewis going to be, or John Doe, is he going to be testifying again? Because he's not part of the charges. And if you remember in the other motions, Bongine has said, you guys let all this bad act testimony come in. And so are they going to try to use that bad act testimony as the actual evidence for the crime? Okay, so keep an eye out. They further say Kelly is charged with 4 counts of producing child pornography, 4 counts of inducing, enticing minors to engage in criminal sexual activity. Kelly and Darrell are also charged with conspiring with others to obstruct justice relating to child pornography and child exploitation, and with receiving child pornography. Kelly, Brown, and Darrell are charged with conspiring to receive child pornography. In pertinent part, the superseding indictment alleges the following regarding the conspiracies to obstruct justice relating to child pornography and exploitation and to receive child pornography charged in counts 5 and 6. They go further, they say Kelly, Darrell, and others knew of Kel's sexual conduct and sexual acts with minors and knew that Kelz recorded himself engaged in sexual contact and sexual acts with minors on videotape. In approximately 2001, Kelz and Darrell learned that multiple videotapes are out there, which we know all this. They're further saying in order to conceal and cover up the evidence that Kelz and Darrell and others agreed to collecting the missing videotapes, that had allegedly Kelz on deck getting it in, okay? The government says Brown is included in the and others language, okay? And it says, language of the conspiracy counts of the government will present such evidence at trial. Okay? As defendants' motions note, the government may seek to admit evidence that Brown, on behalf of Kelz, discussed and or booked hotels, rooms, and made travel arrangements for minor 4 and 6 because they were under 18 years of age. If so, minor 4, minor 6 would be expected to testify further that they engaged in sexual acts with Kelz in those hotel rooms or other locations. Because remember, in that motion from Brown, he said, limit the government from asking me or asking details about booking the hotels. It's in another video, so if y'all ain't hip to it, it's in the playlist. Accordingly, this is direct evidence of Kel's enticements to engage minor 4 and minor 6 in sexual activity as alleged in counts 11 and 13. This evidence is also direct evidence of Brown's knowing receipt of child pornography as charged in count 6. The government must prove that Brown knew that the tapes that he was conspiring with Kelly and Darrell with contained child pornography. In other words, Brown's knowledge that minors were depicted in videos 2, 3, and 4 is essential and relevant to count 6. We conclude that the term knowingly extends both to the sexually explicit nature of the material and to the age of the performers. Accordingly, Brown's knowledge of Kel's involvement with minors, aka booking hotel rooms and making travel arrangements, particularly when considered alongside his, Kel's, and Darrell's efforts to collect the missing videos that depicted Kel's engaged in sexual conduct and sexual acts with minors, is probative of Brown's knowledge of what was depicted on videos 2, 3, and 4. Moreover, Brown was discussing booking hotel rooms and travel arrangements with minor 4 and 6 in and around the same time when Kelz is alleged to have produced videos 2, 3, and 4 involving minor 1. And in addition to Kelz engaging in sex acts with all 3 of these minors during the same time period, minor 4 is expected to testify that Kelz engaged her and minor 1 in sex acts together, and minor 1 and minor 6 are expected that Kelz engaged them in sex acts together. For all these reasons, Brown discussing and booking hotel rooms and making travel arrangements for minor 4 and minor 6 is direct evidence of Brown's knowledge as required for count 6 and is not against Rule 404 evidence. And again, that's the hearsay or the bad acts evidence, okay? These rules get tricky unless all of us are lawyers, and we're not. So there it is. The government says defendant's motion should be denied. All right. Evidence about bringing female concert goers backstage constitutes direct evidence of defendant's knowledge of Kel's method of meeting victims. Similar to the above motion, Brown moves to exclude relevant and direct evidence of his role in the conspiracy to recover multiple videos of Kelz engaged in sex acts with a minor. Specifically, Brown moves to exclude evidence that may be elicited from individual B that Kelz would identify girls in the audience at his concerts, ranging in age from 16 to 20 years old. Okay. How are you 16 at a concert? Just want to know. And if you're 20 years old and you went backstage and got it in with Kelz, what the problem is? Huh? That's what I want to know. Kelz joins in this motion as well. Says the government does not anticipate individual B or any other witnesses will provide this testimony, and the government does not plan to introduce it in its case in chief. However, should Brown or Kelz open the door to this type of testimony, the government may present evidence on this topic in a rebuttal case. The court should deny Brown and Kelz motion in limine. So that is the interesting part right there, because if you got him charged with that and the counts are outlined that, so if Brown is charged with booking hotel rooms, and he can't get on the stand and defend himself and say, well, this is really how it went down, blah blah blah. Then if he gets on the stand and says that, he's opening the door. Okay, so the government can come in and be like, now you said this, right? Okay, let's explore that. Let's get into that. So now the door's open. So what y'all want him to do? The government appears to be trying to back these guys up where they can't testify. It's like, I dare you. I dare you to testify. Shout out to Alan Browning. Just going through the comments real quick. I appreciate y'all showing up. Be sure to hit the like button, share, subscribe if you haven't already. Replay gang, leave a comment. I want to hear from you. Shout out to Alexis Monet, aka In Living Color TV. Let's see. Running through these comments because I don't want to leave y'all hanging, and y'all might have a good question. Let me see here. Shout out to Too Persuasive in the house. All right, y'all. Hold on here. So, yes, I thank y'all for pulling up. So let's get back into this. So it does. It sounds like the government's like, I dare you to get on the stand. I dare you to defend yourself. All right. Kelz summarily moves to preclude the government from introducing evidence of his prior convictions. Kelz now here comes some shade, y'all, from the government. Kelz one-sentence motion, which is undeveloped and lacks any legal analysis, should be denied. Now, I believe that they're referring to that letter that Kelz wrote that said, or that note that Kelz said, I remember this attorney, but I remember hearing his name, but blah, blah, blah. I don't know exactly what item they're referring to here, but that's a little shady, okay? Kelz prior conviction. On September 27, 2021, a federal jury convicted Kelz of multiple crimes in the Eastern District of New York. Specifically, the jury found Kelz guilty of all 9 counts alleged in the third superseding indictment: racketeering, transporting individuals for the purpose of illegal sexual activity, and coercing individuals to engage in illegal sexual activity. And 4, coercing minors for the purpose of illegal sexual activity and transporting a minor for the purpose of illegal sexual activity. So regarding the racketeering charge in count 1, the jury found that the government had proved all the predicate acts except 2 acts relating to victim Sonia, specifically kidnapping and the Mann Act. Now, I'm not hip to this Sonia. I'm going to have to dig into that to see, because that name is not anyone I've covered. On June 30th, Kelz was sentenced to a total of 30 years imprisonment for these convictions. If Kelz testifies at trial, the court should allow the government to introduce evidence that Kelz has a prior conviction for racketeering that included bribery and an act of dishonesty. Specifically, the government would seek to cross-examine Kelz about his conviction, as summarized below. On or about September 27, 2021, defendant was convicted in New York of knowingly and intentionally conducting and participating in the affairs of an enterprise that engaged in interstate and foreign commerce through a pattern of racketeering acts, including 1 act of bribery. As discussed further below, evidence of Kelz racketeering conviction is admissible under the federal rule. Now, they're saying if Kelz testifies, the court should allow the government to mention and introduce that Kelz has a prior conviction, and specifically, the government will seek to cross-examine Kelz about his conviction. So here's the question: what y'all gonna ask Kelz? You gonna get him on the stand? You were convicted, right? You did these things, didn't you? And Kelz gonna be like, no. Well, you were convicted of it. I mean, what? What's up with the government, y'all? What they doing? Checking these comments real quick. It is crazy, baby Shay. Damn, you absolutely right. Tiffany, only please. Oh, very fishy. Shout out to One Pap. Whose minors 1, 4, and 5? Girl, you better ask. What's my man Jason? Ask Jason. He always come in here talking about minor 1. I don't know, One Pap. I can't really say the names. Shout out to One Pap in the house. Bree Edwards, what's T? They are trying to bully him into not testifying. Both of them. Both of them. Let me see here. All right, let's see. Let's get back into it. So the government says Kel's racketeering conviction for bribery is admissible pursuant to this particular rule. This rule mandates the admission of evidence of a defendant's prior conviction for the purpose of attacking his credibility when the court can readily determine that establishing the elements of the crime require proving, or the witnesses admitting a dishonest act or false statement. This rule, though subject to the same 10-year time block, does not require a finding that the probative value of the evidence outweighs the potential for justice. What probative evidence do you think you're going to get by putting Kelz on the stand and asking him, weren't you convicted? Because it's damn near the same charges for Illinois that you have for that you had for New York. So what's probative value where? Y'all just want to do everything you can to make Kelz look guilty of what he hasn't even, the jury hasn't even, deliberated on yet. Okay? They haven't even received the case. All right. Let me see here. I'm scrolling through these documents, y'all, because I'm not about to fill y'all up with the unnecessary. All right. The government further says, if Kelz testifies at trial, the court should allow the government to cross-examine him on the 2021 racketeering conviction for purposes of attacking his character for truthfulness. The relevant act with which the government moves to impeach the defendant is his conviction for bribery, per the indictment. It says this, together with others, did knowingly and intentionally cause another individual to promise and tender to a public officer and public employee property, to wit, United States currency, that such public officer and public employee was not authorized by law to accept. Okay, let me interrupt that real quick and say, did they accept it? Because wouldn't it be attempted bribery? And if it is bribery, where's this public officer and this public employee? Do y'all got them in an orange jumpsuit yet? Okay. So they weren't authorized to accept with the intent to influence the performance of an act related to the employment and function of a public officer and public employee, to wit, the creation of a fraudulent identification document for Jane Doe number 1, an individual whose identity is known to the grand jury in violation of Illinois Criminal Code, blah, blah, blah. So that sounds like, what's her name? Lisa Van Allen, because I was just checking something out earlier today. Shout out to, what's my girl's name? Hollywood Next. She had mentioned today she had mentioned the Vlad TV interview that that the girl did. I can't remember the girl's name, but she's an AKA defendant. But she was saying that Kelz Nem had told her where to go get an ID and this at 2/3. So I don't know who Jane Doe number 1 is. I'd like to know. But anyway, moving right along, this conviction falls within a 10-year window and involves dishonesty and fraudulent misrepresentation that bear directly on Kel's credibility. Kelly was convicted of bribing a public official to create fraudulent identification document for the purpose of deceiving others who were apt to mistake it as valid, as a crime committed by dishonest means whose sole purpose was to further an unlawful deception. The bribery conviction has all the essential elements of some criminal falsi or something. Accordingly, Kel's conviction is admissible for the purpose of attacking his credibility without any consideration of its potentially prejudicial impact. Yeah, I think the girl's name is Lisa Van Allen, who I'm referring to. I don't know if she's Jane Doe number 1 or not, but she said that when she got to I think it was in Georgia. She said when she got there, the Kells was like, okay, well, do you have an ID? And him and Brown gave her money and told her where to go to get her ID. Okay, so we're going to keep an eye out on that one. And y'all can check out that Vlad TV interview with Lisa Van Allen and see what she's talking about in there. All right. Should the court allow evidence of Kel's prior conviction to be used for impeachment purposes, the government moves, per direction from the Seventh Circuit Court, to limit its questioning to the particular felony charge, the date, and the disposition. So essentially, it sounds here like what they're saying is they're just going to ask him, were you convicted of this? Were you convicted of that? On what day? And were you found guilty? Yes or no? Yes or no, Mr. Kelly? Yes or no? You know, that they're going to say, Your Honor, permission to treat as a hostile witness. Okay, let me quit playing. All right. Let's go further with me. They say here, too, Kel's racketeering conviction for bribery is also admissible. Okay. Scrolling down, it says second, Kells was convicted on September 2021, and his conviction will be less than 1 year old. Kells' conviction is not remote in time, and there is nothing about the defendant's subsequent history after the conviction suggesting that the conviction is no longer relevant to his credibility today. True. Most significantly, the fourth and fifth factors of the balancing test overwhelmingly support the admission of the conviction for the limited purpose of impeaching Kel's credibility. Presumably, Kells would assert or suggest during his direct examination that, for example, he did not know that the minors he had sex with were under the age of 18, or that he did not take any actions to obstruct justice in recovering the child pornography videos that he produced. Admission of Kel's conviction is appropriate to evaluate his credibility, where conflicting accounts are offered by the defendant and the government's witnesses. The credibility of the defendant becomes the central issue in trial. So, government witnesses and these witness victims, as the Illinois government is referring to them, are those two different people? Is one of the witnesses Darrell? Is Darrell going to get on and say, yeah, I told Kells don't do it. The girl came to me and told me that she was underage. I told Kells that. Is that what we're doing? Because we know Darrell been free. He is not trying to get locked up. And if Darrell got locked up, would they have him on suicide watch? I wonder. Perch, where is this? Where, you said what? Where is this hide now? Say what? No, wait, hold on. She committed so many felonies, yet she walks. Hit that chat again, Parch, and let me know exactly what you mean, girl. One Pap said, oh, so this is where they try to use the 10 years of consecutive behavior, bribery, still don't constitute 30 years. Girl, you already know it don't. Absolutely. Did you say I'm yelling double jeopardy? Let's see, failure to protect underage and report arrest the official. Absolutely. And we're about to get into that. This government is a trip. Illinois is a trip, y'all. All right, let me see. In the event Kells testifies in this case, his credibility will be a central issue at trial. Kells may dispute other witnesses' versions of events or claim that he had no involvement in criminal activity. If a criminal defendant testifies at trial, the government may cross-examine him or his prior felony convictions for purposes of attacking his character for truthfulness. The jury is entitled to evaluate the credibility of Kells' testimony in light of his prior felony conviction. The importance of Kells' testimony and the centrality of his credibility outweigh any prejudicial effect and permit proper impeachment as contemplated by the rules of evidence. Any prejudicial impact of the conviction is outweighed by the fact that the conviction speaks to Kells' disregard for law and authority. This government, somebody took a writing class, okay? Somebody wanted to be a journalist before they actually went into law. This is some damn good writing. but I don't like what they're saying. Okay? I don't like what they're saying here. So they said here, it says, Kelz concedes that evidence relating to co-defendant Darrell and his role in negotiating settlement agreements on his behalf could constitute relevant evidence in this case. Indeed, Darrell's role in providing services to Kelz to protect Kelz's image, reputation, and assets. What assets, Darrell? Where's the money at? Indeed, Darrell's role in providing services to Kelz to protect Kelz's image, reputation, and assets in the face of actual and potential criminal and civil actions involving individuals who were victims of sexual misconduct by Kelz is alleged in Count 5 of the superseding indictment. In addition to the allegations that Kelz and Darrell conspired and agreed to pay money and provide benefits to individuals in order to 1. Track down and return videotapes, 2. Conceal and cover up evidence of Kelz's sexual abuse of minors, including by making false statements to law enforcement, interfering in the investigative proceedings, and 3. By declining to make statements to the public regarding Kelz's abuse of minors. Notwithstanding, Kelz moves to exclude evidence that Kelz was sued and the cases were settled to the extent it is introduced solely to show Kelz's bad character. Okay, so you want to introduce this information solely, okay, singularly, only for the purpose to show Kelz's bad character. But how about showing the bad character of the alleged parents who took the money and the alleged young ladies who took the money and came back and took the money and came back and took the money and came back and round and round and round? How about that? Oh, that's right. You don't got them up on charges. Okay. To the extent the government offers evidence at trial that Kelz and or Darrell settled with victims of Kelz's abuse, the evidence will not be offered solely to show Kelz's bad character or otherwise for Rule 404 purpose. Rather, the government may offer evidence that Kelz and or Darrell made payments to minor victims and others as direct evidence of the conspiracy to obstruct justice alleged in Count 5 of the superseding indictment, the conspiracy to receive child pornography alleged in Count 6 of the superseding indictment, and the receipt of child pornography alleged in Count 7 and Count 8 of the superseding indictment. For these reasons, the court should deny Kelz Nem's motion. Okay. Y'all talk to me real quick. Y'all talk to me. Parch, if I'm understanding you correctly, it's Vlad TV on YouTube. It's an interview he did with Lisa Van Allen, and she's in there talking about, Kelz told her this. One minute she's saying, yeah, Kelz told me this. And then the next minute when it suits her narrative, well, you really can't believe, you know what I'm saying? You can't believe it, Kelz, what he meant. Like, girl, make up your mind. Damn. All right. Sorry, I told you I had an attitude, so I'm sorry. All right. Checking these comments real quick. She said they sent her to get an ID. Oh, my comment was, oh, that's a good question. Or record of that ID, Parch. Absolutely, girl. Tiffany Only Please said, there is no way in hell Miss Bonji will allow him to testify so that he can stop with this pressure. You said there's no way in hell she will allow him to testify so that he can stop with the pressure. And now, Tiffany, I'm not sure if I fully understand what you mean, because remember, one of the motions, Kelz said he's got some very important testimony about, I think, count 6, 7, and 8 or something of that nature. So I think Kelz does want to take the stand. Okay. But we're going to see, you know what I'm saying? We are going to see. He was getting his braids done with that. Okay. Right, Alexis. He does need. They do, and Boozy badass. He's representing. At least he's vocal about it. Sometimes his argument ain't, but I ain't mad. Keep on speaking. Okay, In this case, if this case is so strong, why violate his constitutional rights to defend himself? Make it make sense. Right? Standing for justice, for injustices. So they're actually not violating his constitutional right, but they're trying to encourage him. They're trying to dissuade him from testifying. Because these sound like threats to me. I would be, if I didn't have Bonjean as a lawyer, I'd be like, damn, they don't want me to testify, you know. But he has to if he wants to make it clear, because clearly they're not letting the truth get out. They don't want the full story coming out. Yes, indeed, too persuasive. All right, let's get back into this. All right, let me see here. Where was I at? Kelz moves to exclude uncharged allegations of misconduct by Kelly on the basis that such evidence is impermissible, blah, blah, blah. The government reads this motion as seeking to exclude any evidence relating to Kelly having sexual contact with a minor who is not identified in the superseding indictment. To the extent Kelz is seeking to prevent the government from calling minors or others not identified or otherwise referenced in the superseding indictment to recount their abuse at the hands of Kelz. The government does not intend to do that. Rather, the government expects minor 1, minor 3, minor 4, minor 5, and minor 6 to testify regarding their abuse at the hands of Kelly as alleged in the superseding indictment. So, they're saying they don't intend to introduce other people other than the minor 1, 2, 3, 4, 5, and 6. But they're saying it now. Are they saying it now because Bonjean specifically put in her motion that witnesses that aren't in the, actually going to be called the bad act people? Is this why the government is saying we're not going to call no bad act people? But were you going to, had Jennifer Bonjean not said don't do it, don't allow them to do it? So the government, to me, they're trying to act like they're so upright and in pursuit of justice. I'm sorry, I'm not convinced. The government further anticipates that some of these minors will testify that at times their sexual encounters with Kelz involved others, including individuals not named in the superseding indictment. To the extent that minor 1, 3, 4, 5, and or 6 testify that another individual was present and or was a participant in a sex act with minor and Kelly, this is direct evidence of the allegations set forth in the superseding indictment. The court should deny Kelz's motion in limine. All right. The government does not intend to offer evidence in a number of categories that are the subject of the defendant's motion. The government does not intend to offer in its case in chief any evidence in the following categories, which are the subject of a number of Brown and Kelz motions. Evidence that Brown and Kelz facilitated abortions for minors and other individuals. Okay. Evidence that Kelz had a sexual relationship with his protege Aaliyah and married her in 1994 when she was a minor. Okay. With the caveat that should Kelz testify at trial, the government does intend to impeach Kelz with his racketeering conviction for bribery for the reasons stated in Section 3. Okay. Evidence, this is what they're saying, they don't intend to bring in. Evidence of allegations from sexual partners that Kelz infected them with herpes. Kelz argues that minor 1 alleges that Kelz infected her with herpes. There is no basis for Kelz's argument. There is no such statement from minor 1 in the discovery. Evidence of video recordings depicting Kelz engaged in sex acts with individuals who are not identified in the superseding indictment. Expert testimony from lay witnesses violating the confrontation clause and the rule against hearsay. The government does not intend to offer testimonial evidence from non-testifying individuals subject to the exclusion from the definition of hearsay. That's a little legalese, y'all. However, should Brown or Kelz open the door to this type of evidence, the government may present evidence on these topics in a rebuttal case. So now they got to play hopscotch. They got to play hopscotch in how they defend themselves. And their attorneys are going to have to be spot on, which I have confidence that Bongine is not going to open the door. But I don't know about Brown's attorney, because remember, Brown has the equivalent of a public defender, except on a federal level. Okay. So are they going to be sharp enough to not open that door? And, when Brown or Kelz gets on the stand, and then the state, objection, Your Honor, they opened up the door. I'm going to ask this question. We about to find out, y'all. Shout out to Auntie Nisi in the house. We love you. We love you, Auntie Nisi. Let me see what, he may want to speak, but there's no chance of him doing so. That will be a nightmare. There is not enough preparation for him to come out in a positive light. Yeah. Yeah. It's definitely a girl. It's a gamble. It's a gamble, Tiffany. Only, I mean, if I was Kelz right now, I would be like, just forget it. Just drop everything and just keep me up in here. Shit, because this government, boy, it takes a hell of a lawyer. All right, let's keep going through here, y'all. Okay, in the government's consolidated motions in limine, the government moved to exclude evidence offered by defendants of their lawfulness and or non-corrupt conduct. Now, this is the government addressing what Brown had put in his motion. I said Brown may offer limited reputation evidence. Brown wanted to be able to call people to come in and say, yeah, Brown was good. Every holiday he was dropping off a turkey and a whole dinner and stuff. He wants to be able to do this. So here's what the government is saying in that. In the government's consolidated motions in limine, the government moved to exclude evidence offered by defendants of their lawfulness and their non-corrupt conduct, except reputation or opinion evidence offered by character witnesses in accordance with Rule 405. The government incorporates that motion into this response. So I don't have any confidence in these character letters, because clearly none of the character letters moved Ann Donnelly. Okay? None of those letters. So I don't have any confidence in those character letters. I feel what you're trying to do, Brown, but it ain't gonna make it. They don't care. They don't care. They don't care. Brown moves to introduce character evidence of what he believes is his reputation for being a law-abiding citizen. Brown may do so as long as the evidence is limited to his reputation generally or is offered in the form of an opinion. But Brown may not, as his motion suggests he wishes to do, introduce specific instances of Brown following the law on other occasions as character evidence. Why not? They got a rule for it. But why not? That's what I want to know. Additionally, specific instances of Mr. Brown's character may be introduced if that character is an essential element of a charge, claim, or defense. Okay. All right. Brown should also know that if he chooses to put his character for lawfulness at issue, he will open the door to relevant, specific instances of his conduct on cross-examination. These are threats, y'all. These sound like threats. These sound like legal threats. Oh my goodness. Now, here's what they say. It says, this is the rule that she cited for that. If Brown, saying that Brown's going to open the door for relevant, specific instances of his conduct on cross-examination. The rule they're citing, these are the specifics of it. The price the defendant must pay for attempting to prove his good name is to throw open the entire subject, which the law has kept closed for his benefit, and to make himself vulnerable where the law otherwise shields him. His own witness is subject to cross-examination as to the contents and extent of the hearsay on which he bases his conclusions, and he may be required to disclose rumors and reports that are current, even if they do not affect his own conclusion. They telling him, keep the door shut. Don't come in here talking. This is what Northern District of Illinois prosecutors is coming with. Okay? That's what they're coming with. All right. The government does not intend to ask the jury to put themselves in Brown's shoes and ask them what they would have done if they were Brown. That golden rule law, y'all. We talked about that on the other episode. Brown moves in limine to prevent the government from making golden rule arguments to the jury, asking them to place themselves in Brown's shoes. Kelly joins in this motion. Golden rule appeals in which the jury is asked to put itself in the defendant's position are universally recognized as improper because they encourage the jury to depart from the neutrality and to decide the case on the basis of personal interest and bias rather than on the evidence. That's what Brown and them said too. So why you put that in your government? You could have saved a little bit of paper. In conclusion, for these reasons stated above, the court should deny Milton Brown and Robert Kelz motions in limine. Okay. Now, that same day, Brown and his attorney, Neil, all right, they responded. Now, let me check these comments out real quick, y'all, because I don't want to get them so out of hand that I'm not addressing y'all. Shout out to Lysandra Giller, girl, we all we got. Yeah, I'm glad you caught it too, girl. Appreciate y'all showing up. Hey, y'all be sure to hit the like button, share, subscribe if you haven't already. All right, Replay Gang, you know what time it is. Leave a comment. You don't want to hear from you. Corey Simmons, shout out to you. Thanks for pulling up. The government trying to get an unfair advantage. Our Kelz has a right to defend himself. He certainly does. And they're telling him, oh, you can defend yourself, Kelz, but be careful. Be careful. Okay, we're going to be careful. All right, so here's what Brown and them said in response to the motion I just read. All right, he goes, government's motion of notice concerning Rule 608 impeachment should be denied. I'm just going to get right into the hot tea on the show. Second, federal rules of evidence do not contain any provision requiring, encouraging, or even discussing prior notice in this context, let alone the government's proposed procedure. Further, the omission of such a provision is made more conspicuous by the inclusion of comparable provisions in other rules. Let me scroll up real quick. See something here. Specifically, the government proposed a procedure by which, prior to each cross-examination, defense counsel would have to notify the court and the government of the intent to impeach by specific instances. This request should be denied for 5 main reasons. Yeah, that's right. I think we're going to get into it in this motion. So, the government has said, prior to each cross-examination, defense counsel would have to notify the judge and them and the government of the intent to impeach by specific instances. And if I understand that correctly, they want them to come in and say, Your Honor, we're going to impeach Jane Doe number 99 because she was actually 25 when she met Kelz, or she was an innocent bystander at Kelz's first trial, and we can show that she was in a news article, and somehow she got a fake ID and made a fool of the judge of the security and got entered, was given entrance into the courtroom, and lo and behold, after that she became a victim. That's how we're going to impeach this person, this victim witness. So they want Bongine and Brown's lawyer and Darrell's lawyer to tell them each time they get ready to impeach somebody. Okay, that sounds like regular court to me. But Brown and them are saying that this request should be denied for 5 main reasons. First, the government cites no precedent for such a motion. And Brown's counsel, is unaware of any such precedent. Second, the rules of evidence don't contain any provision requiring or even encouraging or even discussion prior notice in this context. Um, let alone uh, there are no federal rules about the government's idea or suggestion for this particular procedure. Further, the omission of such a provision in Rule 608 is made more conspicuous by inclusion of comparable provisions of other rules. Now, that's just too much for me. It's too legalese for me, all right? Um, I hate when they add their rule stuff in here, but it is legal. So anyway, consider, for example, Rule 404, which requires the government to provide advance notice in a criminal case where it intends to offer evidence of other crimes, wrong acts at trial. Notably, Rule 404 requirement applies only to the prosecution and not the defense, as the government is requesting here. Now, y'all, let's see what Harry gonna do. Let's see if Harry is going to side with the defendants or side with the government. I can't wait to see what he's talking about. Lastly, the motion should be denied for 3 additional reasons. To start, sidebars every time 608 evidence, and let me tell y'all what 608 is. Hold on. 608 evidence is, this Rule 608 is evidence of character or witnesses for truthfulness or untruthfulness. The credibility of a witness may be attacked or supported by evidence in the form of opinion or reputation, but subject to these limitations. The evidence may refer only to the character for truthfulness or untruthfulness, and the evidence of truthful character is admissible only after the character of the witness for truthfulness has been attacked by opinion or reputation, evidence or otherwise. So that's at 608. So let me start right here again where it says, lastly, the motion should be denied for 3 additional reasons. To start, sidebars every time character truthfulness or witness, character truthfulness or credibility of the witness, that evidence is anticipated on cross-examination, would be tedious and disruptive to the defense. They would break the continuity and flow of the trial and needlessly distract the jurors by distancing cross-examination from the information presented during direct examination. And that sounds a lot like what they did in New York. When you go through the transcripts, every 5 minutes, our favorite AUSA Gettys was like, "Oh, we object, Your Honor. Your Honor, we object." Or the judge was jumping in, talking about, "Can you fix your mic, Mr. Kanik? I can't hear you. Fix your mic. I can't hear you. I can't hear you." So why should they every time they, oh, damn, Chicago, y'all tripping. Okay. Relatedly, the proposed procedure would, contrary to this Rule 11, this procedure would waste time, not save it. And finally, Rule 402 relevance judgments should be made during questioning, and that approach is generally preferred. Like, bring it up in while the trial's going on, object, and do a sidebar if you have to, or judge make a ruling. You know, what's all this extra? Why they want all this flair? Why are they trying to be so protective if y'all case is so damn tight? All right, the government argues that its proposed procedure would reduce the risk of irrelevant questioning by addressing the matter prior to cross-examination. But this would put the cart before the horse, because the information needed to make the relevance determination is itself often gathered during questioning. Thus, there's no reason to believe that the proposed procedure would be fairer or more streamlined than the usual standard objection approach. Now, y'all say something in the comments and tell me, now, right? So, I wonder, do I need to drop the link? Because I need to know, does somebody feel like I feel? Is this some BS, y'all? Come holler at me in the comments. The government's tripping. Want to have a heads up to see how ooh, Corey, go on to say that. This is crazy. So the prosecutor doesn't want Kel's lawyers to present nothing. Sounds like to me, Auntie Niecy gone. That's why you got the Auntie of the Year award. You better ask somebody. That's exactly what's going on. All y'all got to say is drop the link. The government trying to cheat the judge to go along with this and side with the government on this. He needs to be disbarred. I mean, like I said, let's see. Is this Ann Donnelly 2.0? What kind of judge is this? His response to the motion, that's what's going to be tea. That's what's going to be tea. And right now, June Brown's attorney is making one hell of an argument. All right, keeping going. Government's motion to preclude argument and evidence of selective prosecution theory should be denied in part. All right, let's see. Mr. Brown has no intention of making arguments or introducing evidence of selective prosecution. Of course, such arguments would be improper. That said, the government's motion is impermissibly broad insofar as it would, if granted in whole, preclude admissible evidence. Specifically, Mr. Brown takes issue with the government's request that defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents. I'm going to read that sentence again, one more good time for the replay gang, okay? Because now we talking about the parents. Specifically, Mr. Brown takes issue with the government's request that defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of minors 1, 3, 4, 5, and 6. In elaborating on that request, the government explained that it hoped to preclude the defendants from deflecting blame for their criminal conduct. Evidence and arguments regarding the parents of minor 1 are relevant for other proper purposes. Consider, for example, the role of minor 1's parents in her continuing contact with Kelz. Evidence of their knowing participation in and encouragement of that relationship would, for instance, go to Mr. Brown's belief that either 1, minor 1's relationship with Kelz was not sexual, or 2, minor 1 was old enough to participate in a sexual relationship with Kelz. Now that is some common thinking, okay? The use of such evidence in this way would not raise the issue of selective prosecution. Thus, Mr. Brown asked that the court grant the government's motion in part and deny it to the extent that it would preclude otherwise admissible evidence of the minor's parents' conduct. Okay? Now listen. June Brown's attorney might be the equivalent of a federal public defender, but damn it, he's doing a damn good job right here. Okay? All right. Government's motion to preclude argument on evidence of non-pertinent traits of defendant's character. An argument that Mr. Brown may offer only limited reputation evidence under Rule 405. Let's see what you're talking about. In Mr. Brown's consolidated motions in limine, counsel argued that the court should permit Mr. Brown to introduce evidence of his law-abiding character by reputation, opinion, and specific acts. In its consolidated motions in limine and its response, the government makes 2 contentions with regard to that request. First, the government moves to preclude argument or evidence of non-pertinent character traits. Second, the government contends that Mr. Brown may offer limited reputation evidence. As for specific instances of that character, however, the government argues that Mr. Brown may not introduce such evidence. So, in my own little sidebar, is the government expecting Kelz and them to think that they're going to say anything positive about Kelz Brown, but watch them say something positive about Darrell. What is that? That's about white. Okay. As for specific instances of that character, however, the government argues that Mr. Brown may not introduce such evidence. Starting with government motion number 12, Mr. Brown agrees so long as evidence of his law-abiding character is permitted as a pertinent trait. In Section 7 of its response, the government concedes that reputation or opinion evidence of such character trait would be permitted at least under Rule 405. The only disagreement here is to whether Mr. Brown may also prove that character trait by means of specific instances under Rule 405, which provides that where a defendant's character is an essential element of a charge, claim, or defense, the character trait may also be proven by relevant specific instances of the person's conduct. So by that, I believe what they're saying is, if Brown wants to come up and say if Brown wants to come up and say, since 2002, I say I became saved, I turned my life over to Jesus, which, and I would never do anything like that or anything like this or anything like that. It sounds like they want to be able to introduce that kind of stuff, but the government, not of that nature, but make the statement in that way, that they want to be able to come in and say, I'm cool because I wash my car every Sunday, or I'm straight because I volunteer at the domestic violence shelter, or I'm cool, you know what I'm saying? And so this attorney, Brown's attorney, is saying that they want to be able to, it says the only disagreement here is whether Mr. Brown may also prove that character trait by means of specific instances, which provides that where a defendant's character is an essential element of his charge, claim, or defense, i.e., I would never do anything like that because I wash my car every week. All right. Turning now to the government's argument that Mr. Brown may not admit evidence of specific instances of his law-abiding character, Mr. Brown asked the court to grant his motion. Number one, in whole. The government contends that Mr. Brown may not introduce specific instances of Brown following the law on other occasions as character evidence. In support of that argument, the government cites two cases. Both of these cases, however, are inappropriate, or inopposite and inapplicable. And if y'all been tuned into the Gunner coverage, that's what the judge ruled why Gunner wasn't given bond the third time. That all the arguments that Gunner's lawyer made to support the reason for him to have bond, that judge said, man, these cases ain't got nothing to do with bond. What you doing? Shit. And so this is what Brown's attorney is saying. Both of these cases that the government cites ain't got nothing to do with it. They're inapplicable. Okay? Mr. Brown's motion to preclude evidence that Mr. Brown made travel arrangements for minors 4 and 6 should be granted. Okay. Now this is Brown, and this is what I think. Y'all tell me what y'all think. This is Brown really, for the most part, saying, by hook or crook, it wasn't me. Now, I don't know about Darrell and I don't know about Kelz, but it wasn't me. And I feel that way because this attorney has in this motion, Mr. Brown's motion to preclude evidence that Mr. Brown made travel arrangements for minors 4 and 6 should be granted. Here's what he says. In his consolidated motions in limine, Mr. Brown moved to bar the government from eliciting testimony from minors 4 and 6 regarding the times Mr. Brown made hotel reservations and travel arrangements for them, presumably conceding that the proffered evidence is inadmissible propensity evidence. And let me just run this real quick because I hate this word. I hate using these words, acting like, oh yeah, I know these words. But we've heard them so many times. It's propensity evidence. Propensity evidence is evidence of one crime that is used to show the defendant is more likely to have committed another crime. So again, what they're saying is, presumably, let me start from the beginning. Mr. Brown moved to bar government from eliciting testimony from minors 4 and 6 regarding the times that Brown made the reservations for the hotel and travel. They wanted precluded, and they wanted considered as inadmissible, presumably conceding that the proffered evidence is inadmissible propensity evidence. The government instead argues that such evidence would constitute direct evidence of the charged offense. The government misstated and misapplied the law on this matter. This evidence is absolutely not direct evidence of the charged offense. Knowingly receiving child pornography, namely a recording allegedly portraying minor 1 engaging in sexual acts on videos 2, 3, and 4, and instead is evidence of other bad acts. As discussed in his motion, this testimony would be irrelevant to count 6. Most importantly, the testimony involved minors other than minor 1, the only minor alleged to have been depicted in videos 2, 3, and 4. Additionally, the travel and the hotel arrangements were made years before the conduct at issue in count 6. And let me check these comments, because I don't want to miss y'all, and I want to be able to answer your question. Let me see. Corey said the government's scared their fraudulent case is going to fall out under cross-examination. You got a strong case. Why are you trying to limit defense? Come on, ain't that right? Let me see. Shadow Night Zero. Let's see. Hello, everyone. Too Persuasive. Shout out. Let's see. Too Persuasive sent me, and I'm enjoying the content and the vibe. You know what, Shadow Night King? Thank you. Hope you enjoy the vibe well enough that when I drop the link, y'all will pull up. We got to talk about this, y'all. Be taking notes. Tatiana Harris, shout out to you, sweet love. Let me see. I'm going through the comments because I'm not trying to keep y'all long, but I do want to acknowledge y'all. Shoot, y'all took the time out to pull up and see me. I ain't trying to ignore you. Once you do it once, you do it again. It's how they feel. Yeah. And Park, you make a really good point because, listen, Kelz whatever Kelz was acquitted of in 2008, Kelz did turn over a new leaf, at least to the extent where he started checking IDs and keeping copies of those IDs. Now, damn it, that's a effort to keep himself out of hot water. Okay? And that should be acknowledged. Period. All right. Let's get back into it, y'all. All right. Notably, the government hints in its response that the testimony may be relevant to the allegations against Mr. Brown in count 6 because count 6 partly incorporates count 5, which y'all, if this don't sound like a bingo game. Notably, the government hints in its response that the testimony may be relevant to the allegations against Mr. Brown in count 6 because count 6 partly incorporates count 5, which briefly mentions but does not otherwise substantially involve minors 4 and 6. Specifically, because Mr. Brown is supposedly included in the and others' language of the conspiracy counts. The government argues that the hotel and travel arrangements provided for minors 4 and 6 are admissible. Although not spelled out in the government's response, the argument would depend on the contention that the government can prove what is alleged in the indictment. In this way, the government offers another attempt at admitting this testimony against Brown as standard direct evidence, which is in opposition to Rule 404. Evidence by casting a lifeline out to count 5. Like, y'all just trying to really make it stick and make it fit. If it don't fit, don't force it. So what y'all doing, government? We know what you're doing. The attempt to use count 5 to get rid, the attempt to use count 5 to get this evidence in against Mr. Brown should be rejected for 2 reasons. First, With respect to Mr. Brown, the travel arrangements are irrelevant to count 5. Okay. That count mentions Mr. Brown, minor 4 and minor 6, only 3 times in total. It mentions that Kelz employed Mr. Brown from 97 to 2019. It mentions that minor 4 met Kelz in 1999 when she was 16, and minor 6 met Kelz in 97 and 98 when she was 13 or 14 years old. And it mentions that Kelz engaged in sexual acts with minor 4 and minor 6, and that Kelz recorded himself engaging in those acts with minor 4, among others, not including minor 6. Nowhere else does count 5 mention Mr. Brown directly, or minors 4 or 6 directly or indirectly. Indeed, in terms of the alleged conduct underlying the charged offense of conspiracy in that count, minors 4 and 6 are not discussed at all. None of the overt acts have anything to do with either minor. Second, and more importantly, the incorporated language from count 5 is, shoot, I forgot how to pronounce this name, y'all. I can't even pronounce it, y'all. I think it's called surplusage. It's really surplus, but they don't put the edge on there for the legalese part of the surpluses. Anyway, now surplusage is language contained in a pleading that is unnecessary or irrelevant. Okay, so again, Brown's lawyer is saying that second and more importantly, the incorporated language from count 5 is surplus. It's unnecessary to count 6 with respect to Brown. That is, nothing in that incorporated language is necessary to determine Brown's guilt or innocence as to count 6. The incorporated language, especially, and he goes through these particular parts, is of no consequence to count 6's allegation that Mr. Brown helped Kelz retrieve the videos of minor 1. As unnecessary, hold on, let me get that word up again. Unnecessary language, evidence that the government argues supports the count 5 language. But when, okay, I'm sorry, y'all. Ultimately, what he's saying is, just what does he say here? Hold on. The attempt to use count 5 to get this evidence in against Brown should be rejected. Y'all just using all this language and they're not adding up. That's essentially what he's saying. You're using them words, surpluses, and I can't even pronounce it right. But you're using all this language. You're trying to throw 5, count 5, and lean that into 6, and take 6 and lean that into count 5 in a way to tie June up and through there. And his attorney is saying, no, it says evidence that the government argues supports the count 5 language, period. It's irrelevant to count 6. Thus, the government's attempt to pad their argument by reference to count 5 is unavailing and should be rejected. That's a good attorney that he caught that. Now, again, it is worth noting that beyond the relevance issues discussed above, if considered Rule 404 evidence, the testimony still constitutes improper propensity evidence if offered against Brown. In short, Mr. Brown outlined possible chains of reasoning that the government might offer and noted that Rule 404 requires the proponent to show how the evidence is relevant without relying on a propensity inference. And remember that propensity is, you did one thing, you do this too. If you snuck on the bus yesterday, you do it today. Let me look at these comments real quick. R. Kelly needs a win in the Chicago federal case. Jennifer Bongine, R. Kelly lawyers need to be ready and put on more witnesses to combat everything the government brings. The government is struggling and worried they might lose. Corey, I'm with you when you're right. I'm with you when you're right. Hold on. Let me see. All this different stuff is bull. Come on through, Parch. See, most times the government has to get so creative to, Corey. Most times when the government has to get so creative to charge you with something, something is wrong. It got to be. Y'all listen to Island Browning. Be sure to like, share, subscribe if you haven't already. Replay gang, leave a comment. You know I want to hear from you. All right, let's keep on going, y'all, because we're almost done with this part. All right, let me see. Importantly, the government does not cite any case law to challenge Brown's framing of this Gomez analysis, and it does not contend that it is not relying on a propensity inference. Indeed, the government goes so far as to offer one of the very propensity-dependent chains of reasoning that Mr. Brown cautioned against in his motion. Specifically, the government makes the following argument. Let's see. Brown's knowledge that minor 1, depicted in videos 2 and 3 and 4, is essential and relevant to count 6. Okay? This is what they're saying. This is Brown's attorney saying the government said that this is so important, that's why we need to have it in here. And that the government had concluded in the other motion that accordingly, Brown's knowledge of Kel's involvement with minors is probative of Brown's knowledge of what was depicted on videos 2, 3, and 4. Now, just a quick sidebar between us, y'all. Just say all this was true. Just say Kells did say, yo, June, go on down there and get them videos for me, man. Do you think Brown said, man, what's on the videos? You think he asked that? I don't think he would. All right. Summed up, the government wants the jury to believe that since Mr. Brown allegedly helped Kells have sex with minors 4 and 6, Mr. Brown should have also known that a minor was likely depicted on the videos at issue in count 6. I haven't read anything in any of these motions that Brown knew what was on the tapes. Okay? Obviously, the argument relies on an unstated premise. In order for the conclusion to logically follow, that missing premise must be some form of the following. Because Mr. Brown helped Kells engage in sexual activities with minors 4 and 6, it's more likely that Brown knew or should have known that the relevant tapes as charged in count 6 depicted a minor. Nothing else would connect Mr. Brown's actions in making hotel and travel arrangements with the knowledge that the specific tapes at the issue in count 6 depicted minors. Not only would that constitute a propensity inference, it would also constitute a compounded propensity inference whereby Mr. Brown's propensity to assist Kells is layered on top of Kells' propensity to engage in sexual activities with minors. Which I interpret that as them saying that, okay, I don't even know if I can even re-articulate it, but let me put it like this. They're saying it as though because I want to make this point here. He says here, this is what Brown's attorney says again. Obviously, the argument relies on an unstated premise. In order for the conclusion to logically follow, that missing premise must be some form of the following. And in that, he's saying that Brown helped Kells engage with activity. It was sexual activity with minors 4 and 6, or Brown knew what was on the tapes in count 6, and he knew that it was minors on there. And when they get down here to the not only would that constitute a propensity inference, making it sound as though they did this routinely. Every time Kells, allegedly had sex with a minor or a threesome or a foursome with a minor, it was routine. It was usual and customary for him to call Brown and say, yo, June, you know what's up? You know what's T? Go on and get them tapes. So this is why this is their argument. This is what Brown is saying. So he says, thus, the government has not and cannot identify a propensity-free chain of reasoning to satisfy this particular rule. Because again, the government said, yeah, bringing this information in is direct evidence, and Brown and them are saying, no, this is propensity. You just want to get the jury an idea and persuade them to think that, this is a reoccurring thing and they do it all the time. They got it down to a well-oiled machine. All right. So as for the government's request to admit this evidence against Mr. Brown's co-defendants, Mr. Brown offers two possible responses. One, should the court allow this testimony against co-defendants, here we go, y'all, against co-defendants Kelz and Darrell, or both, as direct evidence of counts 1 through 5 and 7 through 13, Mr. Brown would need to be severed. Alternatively, Mr. Brown asks if this testimony is allowed, the witnesses refer to him by either a pseudonym or as an unnamed, unidentified employee of Kelz. Now y'all got that? All the way up to this motion, June Brown's attorney is making one hell of an argument. And so we're damn near at the end, and June Brown's attorney says, now look, if y'all gonna do this, if you're gonna do it, then you either need to sever this. Well, we know the judge is not gonna sever. He ain't gonna sever none of this because it doesn't help Darrell. That's my opinion. He ain't gonna sever these cases. Darrell got to point his finger at somebody, so he's not gonna sever. And so this attorney, Brown's attorney, says, alternatively, Mr. Brown asks that if this testimony, if you ain't gonna sever it, then the testimony, if it's allowed, that the witnesses either refer to him by John Doe 88, i.e. pseudonym, or as an unnamed, unidentified employee of Kelz. This would allow the government to use his testimony to prove the allegations against his co-defendants while avoiding improper uses against Mr. Brown. Y'all not going to tell me they're going to be pointing fingers at each other. It's going to be some finger pointing going on, y'all. There's going to be some finger pointing going on. If I was Kelz attorneys, I would tear them up. Come on. They talking crazy. Now see, I was feeling Brown for me. I was like, okay, June. I was thinking him and Kelz, they was riding and down something. Okay. Part, you said, why isn't the blackmail in this? Maybe that's going to be some surprise information. Maybe that's why the government is trying to put all these constraints on here. This is just crazy, ain't it? This is ridiculous. I don't know how Kelz has the strength. I really don't. I'm going to be honest. Whew. I could cross-examine the witnesses and tear them apart. Imagine what Jennifer Bonjean going to do to them. Say it, Corey. Brown knew everything going on. Allegedly. Because we don't know. Yeah, I feel you, Auntie. I don't know. The thing is, what's really on the tapes? Just because the government said this and that's on the tapes, see, is that really even on the tapes? Anna Brown said most people look as things before turning it over unless it's already wrapped up in the form of a gift. I still find that old man with the tapes weird and FOS too. Right. But see, that's good. That's a good perspective, Island. Because really, here's the thing. If I was just going to pick up the tape, because it's not saying Brown and them had anything to do with money. Okay. So if Brown, and back in the day, they say if you in the hood and somebody you don't know, they run up on you, be like, hold this bag. Don't hold that bag. Okay. Because as that guy's running away, here come 12. And now you're holding the evidence. So Brown may have just pulled up and said, beat the horn like, boop, boop, hey, bring them out. So he never really has seen them. I don't know. And again, there's so much convolutedness going on about the tapes. We don't know yet. We'll find out when the trial happens, but we still don't really know what's on the tapes. And the alleged tapes that they claim that have been seen, they're saying that, and check out Prima Donna. Check out Prima Donna on YouTube. She has got some hellacious, good, detailed information on her community on her community page. So go over there and check it out because she does have a picture um, where, well, y'all go over there and check it out and you'll see. So we don't know what's really on the tapes. Okay. We need to get that in court because Kelz might have to jump up from behind it. I done told y'all that ain't me. You know what I'm saying? We gonna find out. We gonna find out. You and me both, Corey. What did Corey say? Oh yeah, y'all could tear him up. Girl, Bongine is all white. Okay. Tatiana Harris. She's a 100% white woman. Bongine does sound like a Haitian name. So maybe we'll come to find out later, Tatiana, that Bongine was adopted. Who knows? That's a good question, though. Finger pointing is inevitable. Absolutely too persuasive. Hold on, let me see. Railroad all day. Nothing because they would have been leaked. All right. Now hold on, y'all, because we almost done with this. So, Mr. Brown, June Brown said, if you ain't going to sever the case, which we know it's not going to be severed, he said, then let the people call me John Doe something, or let them call me unnamed, or individual 18, or some mess like that. Okay. All right, June Brown. Lastly, should the court decide that the Rule 404B does not preclude this evidence, Mr. Brown asked the court, preclude this evidence under either Rule 402 or 403. Okay. First, the testimony would not be relevant to the charges against Brown. As identified in Rule 401, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. Here, the evidence would not satisfy that definition. Most notably, the testimony would not make more or less probable any fact of consequence to the allegation in count 6 against Brown. The fact, which is the on the making of the videotapes and having sex on tape. The count does not even remotely involve minors 4 or 6. Instead, it involves conduct from August 2001 to April 2007 by Mr. Brown, Kelz, McDavid, Individual A, Individual B, and unnamed others to retrieve tapes depicting Kelz and Minor 1. Notably, the testimony by minor 1 and 6, minor 4 and 6, refer to actions taken long before that time frame. Second, if the testimony has any probative value, it is substantially outweighed by the danger of unfair prejudice, confusing the issues, and misleading the jury. And remember, in the government motion that I read before we got into this one, the government said, inflammatory or making the jury feel some type of way outweighs the pursuit of justice, outweighs how it might make the jury feel. Words to that effect. Y'all hit the replay and you'll know exactly what it said. But so he's saying, and he's Brown's lawyer saying this again. He's saying if the testimony has any probative value, it is substantially outweighed by the danger of unfair prejudice, confusing the issues and misleading the jury. But the government's like, we don't give a damn about that. It's evidence and we want it in. This is a complex case with more than a dozen counts, some of which directly involve minors 4 and 6. Allowing the government to elicit this testimony would risk confusing the issues as to the counts and misleading the jury as to the potential scope of Mr. Brown's criminal liability. Additionally, this testimony would create a risk of unfair prejudice as Mr. Brown could be held accountable for actions unrelated to the alleged conduct for which he is charged. Conclusion. For the above reasons, Mr. Brown asks that the court grant his motions in limine and deny in whole or in part government's motions in limine. All right. I'm about to drop this link. I hope somebody won't talk about this. This link is coming, y'all. We got to get the link in here. If y'all want to come up, say, drop the link, let me know. All right, it shouldn't take so long to drop a link. Lord have mercy. All right, link is in the chat, y'all. Come through. You are invited. You are welcome to pull up and share your point of view. Offer any insight that you may have. Um, let's get into it. Let me see. Yeah, Tatiana, she's white. But listen, girl, and I said this before. Bongine really needs to be mentoring some young black female attorneys because we need black women who are capable and qualified and professional and knowledgeable. We need some mini Bongines running around here, okay? And we need her mentorship. So if you're a female and you're black and you're young, you're trying to get in the law, y'all need to send Bongine an email. Say, hey, look here. I appreciate you representing our brothers in the game. And I would like you to put me under your mentorship so that I can be just as good for you and fight for the right. Huh? Come on. That's what I think. I said, unless she's Cuban. I mean, Cuba and Haiti share land. Say it, Alan. Thanks for that geography lesson, baby. Nick Q. Hello, Nick Q. Thanks for pulling up. We appreciate you. Let me see what else y'all saying in the chat. Hey, the link is in the chat. Ain't nobody coming up? You're right, Tip. J-Rock, get up there. Corey said, really, this is double jeopardy, but the government is using different wordplay and language to get around it, charging him slightly different to get around the statutes. It's that RICO that's giving them all the leeway, y'all. It's that RICO. It's giving them the leeway to do all that. Let's see. You should get up there and talk about how you feel about what you heard the last time I and the others were there. Okay. Hey, listen, I get it. What is it? Folks is probably just getting in from work or whatever. And, may not be the best time. It's all good. I just wanted to bring y'all these details. And one last thing I did forget. So there is a protective order now governing the court proceedings, which the government had asked for their witnesses. So the Judge Harry, good old Judge Harry, he goes at trial, during pretrial, post-trial proceedings. In this case, the victim witnesses, minor 1, 3, 4, 5, and 6, in this superseding indictment shall be permitted to testify using pseudonyms or their first names only. Okay? At trial or during pretrial, post-trial proceedings, these same victim witnesses shall be referred to by their pseudonyms or their first names only. It's nothing new like they did in New York, talking about some Jane Doe number 1, 2, and blah, blah, blah. Okay. At trial, blah, blah, blah. Let's see. Pseudonyms or the Jane Does. Here's the tea. At trial and during pretrial and post-trial proceedings in this case, minor 1's mother, where's Sean David Way at? The way he be saying, Mom. Shout out to the Sean David Way show. The way. Anyway, I'm sorry. I don't know. At trial and during pre-trial and post-trial proceedings in this case, minor 1's mother shall be permitted to testify using a pseudonym and shall only be referred to by a pseudonym. Okay. So that's the court order, y'all. Says all documents that disclose first and last names of the minors and the mother must be filed under seal. All publicly filed documents shall refer to those witnesses by a generic name, such as minor one or minor one's mother. The protective order supplements that previously entered protective orders governing discovery, all of the provisions, da 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 da. When I read this, y'all, I'm gonna be honest with you. When I read this, I'm like, what about so? Because some we be using some of these minors' names. Now, I don't believe that order. Who this is? Who we got? Let me see. Hey, who we got?
Hey, Auntie, this is your Auntie.
Hey, Auntie Nisi in the house. Hey, baby. Good to see you. Thank you for
What's
pulling up.
going on?
Hard work, sweet love. How you doing?
Yeah, I'm doing good. This is this case is for one thing, it's unnecessary.
Mm-hmm.
I think the parents should go to jail because
Right.
how you gonna sell your kids your child to an entertainer, and then when you don't get what you want to get on social media and talk crazy. You knew what your children were doing. You knew where they were. All y'all did.
Mm-hmm.
So it just don't make no sense to me. They're trying to railroad him, just like they're trying to do all them other guys.
Exactly, Auntie. Exactly.
It's
Yeah.
crazy. It's
Yeah.
crazy.
You are absolutely right. I agree with you 100%. Um, and the only difference between this case and um, the one that went on in New York is Kel's lawyer, Jennifer Bongine. That's the only reason why I'd hold hope out because of that.
Yeah.
Hmm. All
Uh,
right.
Tails need he needs some lawyers.
He needs some what,
He
Auntie?
needs he needs some real. You know what I mean? He needs see. It's all kind of attorney. You got like here in Memphis when you going through a criminal case like this or murder, something like that. Everybody know you go to the valley. That's the valley. It's a family, a lawyer, daddy, mama, sister, brother. That's where you go to. That's the valley. I know you remember when that white lady shot her husband. He was a preacher, and she shot him,
Hmm.
and the lawyer got her off on community service. It was years ago. Everybody was talking about it.
Hmm.
But she shot him here in Tennessee, some part of Tennessee. She was a white lady.
Okay.
She shot
And
him
so,
in the service.
so did she
And
get a
she
good
got her
attorney?
off.
Mm.
She got off.
Okay.
She got
Okay.
her off.
Perfect.
That's what I'm saying.
Yeah.
Uh, R. Kelly just needs some better lawyers.
Well, who he has right
Because,
now, who he has right now, Jennifer Bongine, Auntie is
mm-hmm,
look, she way better. If he would have had her coming out the gate for the New York trial, Kelsvin wouldn't even be in jail now. He wouldn't even been no RICO.
right.
So that's the positive to all
And
the.
that's another thing.
Mhm.
Now, how he get a RICO? People who don't have no money, no.
Well,
You
I
know?
mean, they don't care. The government don't care if he didn't have no money. They just like, oh, you're black. Oh, okay, and we can put this up on you. Okay, there you go. They don't,
When you
as long as they get them locked
when this
down.
fight
That's what
first
the goal
started,
is.
this type of say R. Kelly ain't had no money, phony had took all his money. He ain't had no money in his bank account, and he didn't know what he had, and all this
Well,
crap.
right. Well,
So now
before
they want to give him a RICO.
Well, his trial in New York was a RICO, and then this one in Chicago is a RICO, and then Chicago also has a state case against him, and then he got that case in Minnesota, which is a state case. So
So,
they done threw the whole legal system at him. Okay, and that's why these things are so important because they're about to set some hellacious precedents up in here, and that's why it's important that there's a strong, strong fight for Kels. So, and let me see. When Persuasive said that's a good question, Auntie, it really is. That's a damn good question. So now hold on, let me check this comment here. Tiffany Only Please said, I'm not sure who may be better than Bonjean, but I'm sure there are a few, but she's a female. Cochran. Yeah, Bonjean only, to me, she carries the weight. There's always somebody better. But at least this one stepped up to get involved.
But I'm glad he
So,
got somebody. I'm glad he got somebody that's gonna fight for him. You know what I mean? Because
absolutely.
I see, I've been following this for a minute now,
Hmm.
and to me, now, uh, I tell you wouldn't be the only person sitting there.
Hmm.
But if it was me, she wouldn't. Where the parents at? You see, they quiet as hell now. You couldn't
Right.
even get on YouTube a couple of years ago.
Mm.
All the mamas, the daddies, everybody,
Hmm.
the sisters, the brothers, everybody on YouTube now. But suddenly everybody quiet, ain't nobody saying nothing. Why?
Mm. Right. I noticed that
Y'all,
too.
y'all,
I just didn't say
was
nothing. I
y'all knew
noticed that
what
too.
was up. Y'all knew what
Yeah,
was up.
that's right, Auntie. They went crickets. They went crickets on them. They went crickets on them.
And then y'all gonna turn around and do that weak ass special. That old weak ass shit y'all did. So I
Mhm.
survived it out there. Yo, sit
Right.
your horse ass down. You already know what time it
Mhm.
was. When you got to the studio, bitch,
You're
you
right.
girl, they need me.
Right.
I ain't trying to disrespect your platform, girl, but I'm
No,
getting mad now. Just
I
thinking
got you.
about it.
I understand. We feel you. We
I,
feel the same way.
I ain't trying to disrespect your thing, man, but
No, 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 sweet
every
love.
time I think
See,
about the
yeah,
girl and
yeah.
they mama and them, because what's that little girl name?
I don't know, but with this
Ariel
protective
or
order,
whatever.
Auntie, with this protective order, we may not
Yeah,
want to say them names no more.
okay, bro. With that little
I'm playing.
girl,
Girl,
she
say
was
the
something
name. It's out
serious.
there. Hell, we won the first one. Shit, it's in print. Shit, she done did her little interviews.
She was something. She was the worst one.
Hmm.
Her and that other girl.
Yeah.
You don't want me
All
to say
right,
that name.
Auntie.
I won't say that name. But they was
No,
something else. So
no,
man, you
we can
keep
say
on
that now.
doing what you do, girl.
Listen, Auntie, they done did all. They done
And
did their
now,
interviews. They done went on their book tours. They done did all what they gonna do. Azriel, she went on Jason Lee. You know, we ain't tripping on that. We're not gonna say all. We're not. I ain't tripping on that. It's out there. You didn't hear it from me first. I heard it from somebody else. So, but I do wonder in this protective order if they're going to try to enforce that moving forward. So, Auntie, what I'm gonna do? I'm gonna drop you down. I'm gonna thank you so much for pulling up. Y'all, I'm gonna keep this link in the chat for just a minute longer. If you want to come up, hit that button. Auntie, thanks for pulling up. I appreciate your sweet love.
and
Uh,
thank you, girl. Thank you.
yes, sweetheart. You're America's favorite,
I
Auntie.
enjoyed the show.
All right, baby. Appreciate
Girl,
you.
I enjoyed the show. And thank you, man.
Thank you, sweet love. I'll be talking to you real soon. All right, y'all. So the link is in the chat. And if you're trying to pull up, I ain't going to be here too much longer. I don't want to keep y'all that long, okay? Y'all know how it go. Corey says, ladies and gentlemen, the government has went back decades to charge R. Kelly, conflating isolated incidents and tapes. Um, yeah, conflating isolated incidents and tapes out of chain of custody issues and were altered, and we're going to prove that. Yes, indeed. J Rock said, if the government keep acting like this, they're going to make Johnny. Ooh, what? They gonna make Johnny Cochran jump up out the grave and join Bon Jean. They gonna make something happen. This just cannot stand. Terrible. I've seen the parents go from radio program to shows only to advertise. Only to advertise their businesses. No real concern for. Yeah. So again, y'all, when I started the show, because ain't nobody put it in the chat, so we getting ready to wrap. But I'll say this: I started the beginning of this episode saying, let's keep an eye on Judge Harry. Judge Harry. Because Judge Harry commuted a man who had a life sentence, and the commuted may not be the correct word, but what I mean is he let the man go free after 20 years. Okay. And his reasoning was, well, if the man ain't learned, if jail ain't changed the man, if prison ain't changed the man by now, nothing ever will. So let the man on out. But you don't let Larry Hoover out because he's still, too soon. You use him to set an example. But come holler at me a little later, Larry. Come holler at me a little later, and we might revisit this again. Larry Hoover been in jail so long that if your reasoning was letting this other dude out, Because after 20 years, if jail ain't changed them, what nothing will. How come that same attitude or that same perspective is not being applied towards Larry Hoover? I mean, there's enough people behind Larry Hoover right now that are like, look, let this man out. Now, I don't know enough about Larry Hoover to be like, he's innocent. I mean, his background is interesting as a mother other, okay? But he's anyway. So we're going to keep an eye on Judge Harry. And by that, I mean, we're going to continue to watch for his responses to motions and how he rules in the courtroom in this Illinois trial with Kelz. Okay? That's what we're going to see. And the next thing that should be coming up is Harry's response, Judge Harry's response to what the government said and to what Brown, we just read that, what Brown said, and or if Bonjean submits a response to the government. So, yeah, we about to be piping hot up in this piece. Shout out to Carla McWilliams. Thanks for pulling up, sweet love. We appreciate you. Y'all be sure to hit the like button, share, subscribe. If you haven't already, Replay Gang, leave a comment. You know I want to hear from you. So that's it. That is the podcast. Y'all be sure to hit the like button, share, subscribe, Replay Gang, leave a comment. You know I want to hear from you. And until next time, y'all, we will see ya when we see ya. Welcome to the Only Male Cruise Show, the podcast. I am the Only Male Cruise. Be sure to hit the like button, share, subscribe, Replay Gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.